Well, thank you very much, Max. It's a great pleasure to be here. But I also teach in Turkey, so I teach in Germany as well as in
Turkey University.
So, yes, at Koç University in Istanbul. Yeah. So it's a dual affiliation. So I'd like to take you a little bit away from the current or the morning discussions on two fronts. One is I'd like to focus on general measures and implementation. And in the previous presentation, the focus was on individual measures, and they're very important, but I'm not going to talk about individual measures and implementation, but solely on general measures. And obviously the second thing is I'm going to take you to Turkey. So we're going to shift on these two fronts. I'd like to do sort of three things. One is sort of what have we learned in the Council of Europe about getting states to implement general measures. So what is the state of the conversation about the state of knowledge about what has to happen about these general measures? And then sort of look at Turkey and what happens in Turkey in relation to general measures. And then on the third part of my presentation, I'm going to look at the Turkish Constitutional Court and its potential to deliver, to implement general measures. So these are the three sort of layers of the presentation. In relation to general measures, there's been quite a lot of thinking within the Council of Europe about this issue. There are lots of things that we all know, that general measures may fall on the parliament, may fall on the executive, or it may fall on the judiciary. And there are lots of repeated knowledge about these things. And we heard in relation to Germany that if it falls on the judiciary, the constitutional courts are the signalers, and the constitutional court signals, and then this sort of is followed through and so on. One of the things, and also within the Committee of Ministers, one of the things that has been learned, because there's a huge problem of implementation of general measures in general, so it's not a Turkish problem, it's a big Turkish problem, is that you have to have institutions, domestic institutions, that constantly has to look after general measures. But this cannot be just general institutions, the state, the parliament. We know that it falls on them, the judiciary. But what we know in relation to our experiences in our regions, however you want to define these regions, the traditional, the parliament must do, the courts must do, it doesn't work. General measures don't come sort of in this way. So the idea is that there has to be specific institutions that own general measures. So the Council of Europe has one recommendation about having focal points within the executive, having intergovernmental institutions that will actually look after general measures. Parliaments are supposedly have to have these independent committees or commissions that look after it. And in the judiciary, the constitutional courts have the highest expectation that they will have to signal about general measures to whoever they need to signal. And there's lots of institutional developments in that regard, right? So one of the things that have been pushed is to create these focal points, the contact points in all the countries. I don't know if Lithuania has one, but parliamentary commissions on human rights and so on. So all these things are being pushed so that there are implementation partners within the states that will constantly push for the implementation of general measures. Because the traditional idea doesn't work. We just know that it doesn't work. So you have to have dedicated institutions for that. So, and there are lots of calls to do this. So what is the case in Turkey? So Turkey has a general measures problem. 1,419 judgments awaiting implementation. 184 has leading cases, and that all concern general measures. So we're talking about a significant number of changes of all sorts within this. One of the things that Turkey has done, actually it has been responsive on paper. One of the things that it established a focal point within the Ministry of Justice on the judgments of the European Court of Human Rights and their execution. It's a very small sort of unit, and this unit is supposed to communicate with everybody. They have to write to everyone and sort of find out what happens in relation to general measures. But the way that this institution has been created is quite a weak form of this creation, because it is almost like a post box within the Ministry of Justice. It writes a letter and then just waits for an answer. And then that answer may or may not come. But it doesn't have any powers to give deadlines and say within 3 months you have to respond us and you have to tell us what the general measures are. So they usually just wait. They're in this waiting zone because they don't have any independent sort of follow-up sort of powers, or they're not reading these into these things. Going back to the previous presentation, if you don't have an institution that constantly reminds you of the judgments, it is very difficult to get the political will going if the political will is not in itself receptive to these judgments in the first place. So this idea is constantly nudging and nagging these institutions. So Turkey has something there, but if you ask me, not really. I mean, this institution is not really there. There's been a lot of excitement and talk about setting up a commission or a committee within the Turkish parliament, because this is the heart of general measures. And Turkey needs the parliament to act on quite a lot of number of the general measures. But this project is a very sleepy, it's a very dormant project. You know, the British example, you may have heard about the Polish backtracking. They had one and now they're backtracking on this. There was a lot of preliminary investigations within the Turkish parliament to be able to set this up so that there is a committee that would change the agenda in the parliament and bring the judgments sort of further into the agenda. And this really hasn't happened. The NHRI, there's a new human rights equality NHRI. It doesn't specifically have any guardianship of human rights judgments. So there's no general measure mandate or anything like that. So in a way, Turkey has developed institutional capacity, but they're on paper institutional capacities. And if you look at the way they operate, they don't really cut it. You know, they can't do anything about it. Now, the one institution that has been hailed, and for some very important reasons in relation to general measures, has been the right to individual petition before the Turkish Constitutional Court. They said, look, we've done everything. We've introduced the individual petition, we have this, that. So, but this has been a central focus in general measure issues in relation to Turkey, is the 2012 legislation that brought in the right to individual petition. So I'd like to focus on that because the others are not working. So there is a lot of hope, well, there is a lot of expectations from the Turkish Constitutional Court. No one else, none of the other institutions are delivering. As you would expect, if there is a lot of expectation on one institution to deliver general measures, they won't succeed. It's not going to be very easy to succeed. So there's a lot of high expectations on the Turkish Constitutional Court on this issue. Let's just talk about two characteristics of this big expectation that's placed on the court, but two very specific issues. One is the law about right to individual petition says the Turkish Constitutional Court has jurisdiction on matters that are at the intersection of the Constitution and the ECHR. So it is, you know, there's the smallest bit, it's the dot here. So already the Turkish Constitutional Court, if they did anything, they could only, you know, maybe help in relation to general measures at the intersection of the ECHR and the Constitution. So Turkey has a prisoners' voting case of its own, Söyler versus Turkey. It had inadmissibility decision delivered by the Turkish Constitutional Court. It said, ratione materia, this is inadmissible, this is not at the intersection of the rights in the ECHR and the Constitution, because prison voting is regulated at a different part within the Constitution. So in matters that are not at that intersection, you know, the Turkish Constitutional Court cannot have a contribution unless it interprets that intersection in somehow in a different way. So that's already one sort of chunk of that thing out of the picture. The second issue is the Turkish Constitutional Court's law doesn't explicitly allow it to declare anything sort of unconstitutional or to order general measures through the right to individual petition. So it doesn't say that, you know, if you find a violation that the court may also instruct on general measures. It doesn't prohibit the court doing so either. So it doesn't say you cannot say anything about general measures, but it doesn't also say that you can say things about general measures. And what we have been seeing with the Turkish Constitutional Court's jurisprudence is that they have been incredibly cautious about pronouncing on the general measure aspect of the court. And we have an esteemed judge here, and maybe we might disagree, but I think the Turkish Constitutional Court has locked itself in the paradigm of individual measures. So the highest expectation of the Council of Europe from this institution is very much limited, both because of the intersectionality idea and also because the court sees itself more in the domain of individual measures and not on the domain or in the issue of general measures. Now, obviously, one thing that can happen is that the court may not have any explicit powers to indicate general measures, but it could signal, right? I mean, we heard from the German example that, if there is a jurisprudence, it will be followed by the domestic courts and so on. So I'd like to sort of just look at that, and if the court indirectly, the Turkish Constitutional Court could indirectly contribute to the improvements of general measures. And I will give 3 examples, and then after those 3 examples, we'll conclude. And I think there are very difficult issues with both of these 3 examples. The first one is, what is hailed as a massive success of the Turkish Constitutional Court. 2004, I'd like to highlight the dates of the general measure judgments. 2004, Tekeli versus Turkey. This is a long time ago. We're talking about 12 years of an issue. Women who marry may keep their own last names, should they not, and what have you. And the Turkish Constitutional Court didn't think so a few years, some time back. And then they sort of had an individual case and said, yes, we think under the Turkish Constitution, this is a violation of the Constitution as well. So but the law stands. There is a law that actually says that you have to lose your last name in these cases. So what the Turkish Constitutional Court did is to instruct every single woman in Turkey to continue to litigate. So they said, if you litigate, even if a domestic court doesn't listen to you, you could spend about, 3,000 euros or whatever it may cost. You can come all the way to the Turkish Constitutional Court, and actually get your name. So it doesn't solve the general measure problem in any way, but actually instructs people to continuously litigate in this case. So I was one of the persons who criticized this judgment, and I said, you have to say something about general measures. If this is a violation, there has to be more in the judgment itself. But the court is a bit worried about whether this is a good idea or a bad idea. So what is actually presented as a success is actually not, in my view, a success in relation to general measures. Obviously, only rich people can litigate, women who have the money can litigate, and so on and so forth. And the judgment, the Tekeli judgment, general measures remain unimplemented, despite what we're celebrating as a very nice judgment in the individual case. The second example raises a different type of an issue. Turkey has a very serious general measures problem in relation to peaceful assembly and associations. This is called the Ataman Group cases before the Committee of Ministers, pending as a matter of general measures since 2006. So we're talking about a 10-year long problem that police interfere in protests which may be peaceful, but the police either decides it's unlawful, or it becomes unlawful, or it may become slightly less peaceful, and so on and so forth. So there's a massive jurisprudence of the Strasbourg Court. The Turkish Constitutional Court responded really well to this jurisprudence, and it delivered 2 very important judgments, Erbil judgment and Ali Rıza Özer. These are the Turkish Constitutional Court judgments, where the Turkish Constitutional Court have used the similar arguments of the test of peacefulness in order to interfere in the assembly. So so that there has been a nice sort of match. Obviously, the general measure required in this case is to change the law that will clearly allow for the peaceful protests not to be intervened in. Different problem here is that Turkish Constitutional Court delivered this judgment, but no one is listening. So so there's a signal, a jurisprudential signal out there, but neither the lower courts nor the police or the prosecutors are listening to these judgments, because they continue to prosecute people even if they may have participated in a peaceful assembly. There are interventions, the court cases about violation to the Turkish assembly law. So these are constantly sort of ongoing. So the court is not saying anything about general measures, but as an outcome, it is also unable to stop the violations because no one is listening. The third type of problem that we have with the big expectation on the Turkish Constitutional Court is sometimes the Turkish Constitutional Court does not take into account the general measure requirements of the judgments of the European Court of Human Rights. And the third example will be Batı group cases. Now, these cases have been around since also 2004. These relate to ineffective investigations into the actions of the security forces, with respect to either torture, ill treatment, or right to life violations. And one of the key points in relation to the general measures in these cases is that the prosecution and the domestic judiciary take their time for such a significant period of time that these cases end up falling under statute of limitations, and the moment that they're, the certain amount of years have surpassed, obviously the cases are actually struck out of the list. So in the Committee of Ministers' general measure requirements, this is required as an area where a general measure has to be taken. This, the sort of intentional in a way, so that the way that the proceedings are so long that, the statute of limitations means de facto impunity in all of these cases. The Turkish Constitutional Court started receiving very similar cases from victims of human rights violations from the 1990s, from the 1980s, and so on. But in all of these cases, it has actually held on to the reasoning of statute of limitations and said that, I have been established in 2012. These actions have taken part before the right to individual petition. My critical date is 2012. And if something has been dropped because of the statute of limitations before this date, this is not something that I will have any jurisdiction on, and I would actually declare it inadmissible in terms of rationa temporis. And this jurisprudence, in contrast, stands in very clear contrast with the general measure expectation of all these cases, and the cases date back from 1990s and onwards. So this is a very long sort of group of cases. So in sum, the Turkish system obviously has a very serious general measure problem, and obviously, it's very easy to say, oh, there's no political will, and this is what it is about. One of the things that we do in this regard is to constantly interject institutions. Even though there's no political will, you have to lock in this political will somehow by sort of introducing specialized institutions to create this political will. What we see, I think, in the example of the Turkish Constitutional Court right to individual petition is that it has actually been successful to some extent in relation to individual measures, but it has not succeeded in becoming a partner in relation to general measures for these three different types of reasons that I've outlined in the paper. Thank you.